or seize the property of businesses who cannot pay rent due to the impact of COVID-19, so long as a state of emergency exists. So that is only until April 5th. The state of emergency only exists until April 5th, but it is likely that that will be extended. If it is extended, we'll certainly notify you, but I expect you'll read about it in the media as well. So we continue to try to find ways to support you, and that includes keeping us all connected. And I thank you all very much for your resilience, patience, and of course, continued advocacy for the business community. We are meeting on a regular basis, so in fact, every 2 days with all levels of government, federal, provincial, and municipal, to try to determine what their current status is, any offers or any suggestions that they have for business. And we are providing immediate feedback. In fact, in some cases, real-time feedback. Yesterday, we were on the call with government. We noted, and there are 100 people on that call, I should add, representing associations, businesses, and groups that total over 10,000 businesses in Nova Scotia and over 200,000 employees. We noted that the 5-employee requirement for the deferred rent was inappropriate and unworkable for small businesses. And during the call, the government acknowledged that they would be removing that 5-employee requirement. So we were very pleased to see that as quickly as we could. Now, we will be continuing to provide these webinars and would encourage you to take a look at these. We will have HR, mental health. We're even going to have fitness on Friday. So keep an eye out. You'll see at the bottom of your screen, there is a Q&A, or you can ask a question. I think by clicking on my name. I'm a bit hesitant because this is the first time that I've done a webinar, although I've done many Zoom meetings, but there is a way to communicate with me off to the right as the moderator. And you can ask me questions throughout the presentation. I'll keep track of those and we'll ask Brad at the end. You can message me privately or communicate to everyone. Then we'll open it up to questions for Brad at the end of the session. So next, I'd like to introduce our guest, Brad Proctor, leader of the Labor and Employment Proactive Group at McGuinness Cooper, as well as the Regional Lead Partner, Labor and Employment for McGuinness Cooper. Brad practices management labor law with a focus on occupational health and safety, workers' compensation, wrongful dismissal, labor relations, human rights, and workplace privacy issues. Brad, over to you. I think you might need to unmute, Brad. Oh,
Thank you, Patrick. Can you hear me?
Yep.
Excellent. Well, thanks for inviting me, Patrick. I'm pleased to be able to present to folks, your membership. Thank you for introducing me. I'll just kind of caveat that by noting that in my role as regional lead partner of our Halifax, Nova Scotia office, I am feeling like many of your folks on the phone in that we have approximately 300 employees that work out of our premises. And so not only am I advising clients on kind of legal matters, but I'm actually implementing measures here in real time with our workforce as well. I don't pretend to have all the answers to this evolving situation. It is that, it's fluid, it's evolving, it's changing day by day. But it is something that is a challenge. And you know, I have been working with a number of clients that are doing very creative things from a health and safety perspective, from a benefits perspective. And so what I'll do is I'll go through my presentation, which is kind of a summary of a lot of the issues that I've been seeing. And then perhaps if there's questions, I'll take those at the end. Now, I apologize, the way my configuration is set up is I'll be looking at my monitor to advance the slides. My camera is off to the right. So it will look like I'm not looking at the camera because I'm focusing on my slideshow. So the title of my slideshow is Coping with the COVID-19 Pandemic, 5 Key Workplace FAQs, Frequently Asked Questions that Employers Need to Know. There's many more than just 5, so I'll kind of hit on these 5, and if there are some questions at the end, then feel free to raise those questions. One of the things that I'll note is that you know, it is a long road that we're on. We've now been in this for you know, probably about a month, and I think anyone who's dealing with it will recognize that you know, the way we dealt with things in the first week was very different than the way we're dealing with things now. And there's a great deal of uncertainty as to precisely when this will end. You know, there's all kinds of information in the media from the US and from different Canadian provinces about the impact on different provinces and different countries. And so we can't really fully predict when it will end. The next slide I'm going to share with you is a slide that I can't confess to have developed myself. It's been developed by a colleague that many of you probably know and may deal with. His name is Dr. Matthew Bernstein. And he is a physician. He currently resides in Toronto. He used to live here in Halifax and still has a lot of clients that he deals with in Halifax. But I've been working with him in a couple of situations, and he's developed a slide which I'll show it to you. It's a pandemic curve. And it's quite interesting. You know, I was a lawyer back in the early 2000s when the SARS crisis hit. And it's amazing. A lot of these issues that we talked about in SARS, we're talking about again. But
Brad, sorry, did I just interrupt for just a second? I think we forgot to share the screen at the beginning.
Oh, we did. Okay.
Can we just
Go
start
back to sharing the screen? Okay, let me share my screen here. Okay. Do you see that?
Yep, we've got it. Yep.
So just for people that I was talking there for a little while, I'll just go back very quickly. All that you've missed is really my my title slide when I introduced my title. Then secondly, I told you that it's a long road and we don't know the end. So that was my graphic depicting that it's a long road, that we don't know the end. And the first kind of substantive slide that I've shared is this, this pandemic curve. Can everyone see that?
Yes.
So if you look back, when we were talking about SARS in 2002, 2003, we looked at that every century there are pandemics, and there are on average 3 to 4 pandemics every century. And if you look at the 20th century, there were 3. There was the Spanish flu, the Asian flu, and the Hong Kong flu. And if you take the curves of those pandemics and you overlay them on top of each other, they're almost virtually identical. So this graphic that you're looking at is something that Dr. Bernstein has prepared based on our current COVID-19 pandemic. And so if you look at the graphic from the left-hand side, he notes kind of, you know, with a dotted line, no human-to-human spread, and then sustained human-to-human spread. He then has a bullet where it notes that it arrives in Canada. And that date, I believe, was January 16, 2020. And based on you know, a collection of Canadian data, it's estimated, Dr. Bernstein is predicting, that the peak in Canada will be sometime in that time period of April 20 to April 30. So that's indicated by the arrow at the apex of the curve. And then, of course, we see what's called the acceleration as it advances to the peak of the curve. And then you, of course, have the deceleration period, which he's predicting will be sometime in the period of May 20 to 30. So that's kind of the best estimate we have, at least I have, of how long these measures that were in may last. And I think we're seeing that in some of the measures that our government is enacting, for example, with yesterday's cancellation of school. Now this curve, I don't want anyone to think that this is exact science. Dr. Bernstein has told me that many things will change province to province. If community spread starts to happen more, accelerates, the curve will change shapes. But the other thing to keep in mind as employers is that in past pandemics, there is a second and third peak. So we should keep in mind that when we're hearing in the media that there can be a second wave or a second peak, that is anticipated to perhaps happen in the fall of 2020. As I go through my 5 kind of legal points for you, I do want you to keep in mind that this is evolving. And so the things that I said 2 weeks ago to employers have evolved and changed. For example, when employers called 2 weeks ago and said, geez, I have someone that we have to self-isolate, what's the appropriate benefit? The best advice at that time was employment insurance sick. That has since changed as a result of the introduction last week of the Canadian Emergency Response Benefit. And I know, Patrick, participating in your very useful sessions that you're conducting at lunch, I heard one of the speakers yesterday, I believe it was Bernie Miller, say that policy development is happening in real time. So that is what's going on. So things are evolving. And one thing I'll point out to you as employers, when it comes to things such as benefits, obviously you want to provide your employees with the most information that you can give them about what benefits the federal government's making available. You want to direct them to the appropriate websites, but you don't want to be engaging in making guarantees to them about whether or not they will get a benefit and what timeline that will come in, because those are things that are outside of your control. When we think about our workplace, this is a little summary of legal issues that we need to think about. So I'm going to start kind of at the top of, near the top of my circle, and noting that the first legal issue that we need to think about is the blue circle that I've indicated with public health. So as we know, in Nova Scotia, a state of emergency was declared, and we know that Dr. Strang is providing regular daily updates with respect to various recommended measures. That's kind of a starting point. And that is, as an employer, we need to educate our employees and provide them information on those things. We'll talk in a moment about health and safety, but one of the obligations as an employer is to provide your employees with information with respect to possible hazards in the workplace. So, providing and educating your employees on some of these things that they may not be focusing on is part of your obligation. And of course, it's also your obligation with respect to these ministerial directives, public health orders, to comply. Then we move on to our next circle, the yellow shaded circle, the one that says OHS, or Occupational Health and Safety Act. That's something that we need to remember. There are different aspects of that legal duty. One is we have an obligation as an employer to ensure a safe workplace. So that's a precautionary, preventative legal obligation. So we can't just wait for things to happen and then react. We have to be preventative and precautionary when it comes to health and safety in the workplace. Secondly, of course, when there are things that happen, we do have to react, and we do have to implement remedial measures under occupational health and safety. And my advice to employers is be as transparent as you possibly can with your OHS. So, for example, we're hearing lots of stories of employees that are getting concerned or getting anxious about the workplace. My recommendation is, if you're implementing best practice health and safety measures, implement them publicly, implement them transparently, and let your employees know what they are. So make sure that you're having more toolbox meetings than you normally would. Make sure that you're having more safety chats than you normally would. If it comes to policies and procedures, make sure they're clearly articulated in writing on bright colored paper, and you can bring them to employees' attention. If employees feel that you're implementing best practice safety measures and you're acting in that preventative, if you're viewed as the employer that's being preventative as opposed to reactionary, then a lot of employees' anxieties are going to be, you're going to get the confidence of employees with your handling of this matter. And I'm seeing that in workplaces. I'm seeing workplaces that are on the kind of leading edge in implementing procedures and implementing them in writing and having meetings with employees and getting their buy-in, and it's going a long way to getting employees' confidence. The next legal obligation that applies is my purple circle, which is human rights. And we have to remember, with human rights, we cannot discriminate. So we can't discriminate against individuals because of their gender, their age, their ethnicity, because they have a disease or they don't have a disease. We can't discriminate. And the flip side of the human rights obligation is that we have to accommodate. So if someone develops a condition such as COVID-19, we have to accommodate that. We then move on to my green shaded circle, which is employment standards. Employment standards would be the law which governs non-unionized workplaces in Nova Scotia. In Nova Scotia, we actually call it the Labor Standards Code, but it is in fact our employment standards legislation. And we're seeing that when it comes to the question of layoffs. And we're going to talk on another slide in a moment about layoffs, but that is where employment standards comes in. Workers' compensation. Workers' compensation is not the, what I'll call the, it's not the preventative side of health and safety. It's the benefit that people receive if they are injured in the workplace. I've not seen specific workers' compensation claims yet involving COVID-19. I personally haven't, but I'll talk in a little bit about that. The next is privacy laws, and privacy laws are going to change in a number of ways. If you are a public sector employer in Nova Scotia, then there's the Freedom of Information and Protection of Privacy legislation applies to you. If you're a private sector employer, then that doesn't apply to you. So your privacy obligations are going to change based on a number of circumstances about the type of employer that you are. But you have to remember that the privacy laws aren't relaxed just because there's a pandemic. Employment insurance, we've had some experts that have participated in the Chamber series over the past few days, providing regular updates on that. And those benefits, as I've mentioned, have been evolving. Collective agreements. For those of you that are in a unionized workplace, then when it comes to things like your health and safety obligation, or what benefit an employee might get if they have to be absent for sick leave, or layoffs, those types of things are governed by your collective agreement. So a lot of the things that we'll talk about or we'll read about what employment standards regulators are doing are different in unionized workplaces. For example, I've seen some collective agreements in the last 2 weeks where they have what are no layoff clauses. They're clauses that have been negotiated into agreements where the parties, with all of the best intentions, have said, here's a minimum complement of people that we will never go below. Well, in this kind of environment, the question is, are those enforceable or are they not? So, you need to look at your collective agreement. One thing I will point out, in Nova Scotia, if we talk about the Labor Standards Code and the laws with respect to layoff. In Nova Scotia, when you look at the regulations under the Labor Standards Code, employees that are employed under a collective agreement are expressly exempted from the notice provisions in Nova Scotia. So that's something to keep in mind as well. The next, we're almost around the circle here, employment contracts. Employment contracts are something for non-union employees that we need to think about. We'll talk in a moment about constructive dismissal being a possible risk. And so employment contracts are something we need to look at. And for years and years and years, lawyers like myself, management side labor lawyers, have been telling clients, you should adopt written employment contracts and you should have termination provisions in them. And I'll speak a little bit more specifically about that on another slide. But those employers that have adopted written employment contracts with clear termination provisions, their risk with respect to constructive dismissal, that's something that's much more transparent and calculable than an employer that doesn't have a written employment contract. And as I go about this circle and I look at all of these different laws that apply, it dawns on me that I've not included immigration. And as another set of laws that apply for those that have temporary foreign workers. The good news is that I am not an immigration lawyer, so I can't really give you much more than that. We have immigration colleagues here that practice in that area, but that's another area that we are getting questions on. So I'm now going to move through what I call the 5 frequently asked questions. And the first is really focusing on what I'll call really a compliance obligation. And that compliance obligation is to comply with the orders, ministerial directives, best practices, which are being put out by federal government officials and provincial government officials. And those change and those are varied. And but one thing I do commend or recommend to employers is go to the source of that order or directive as best you can. You'll read lots of reports and there's lots of great media reported on all kinds of different social media and on news of what these things are. But as an employer who's making a decision as to whether or not you lay off or whether or not you curtail a certain aspect of your business, go to the source of those documents. So if you're, go to the order by the medical officer, go to the ministerial directive and actually read those things so you make sure that you're compliant. When it comes to these, I call it a patchwork, a public health patchwork. That's because there are orders coming both from the federal government and there are orders coming from the provincial governments. And some employers, and I'm sure there are some employers that are on this call, I know this is a presentation for the Halifax Chamber of Commerce, and so I'm focusing really on Nova Scotia law, but most of the clients that I'm dealing with, I would say the majority, they aren't solely operating in just one province. They do engage in business in Prince Edward Island or New Brunswick or Newfoundland and Labrador or Ontario. And so you really need to look at what the orders and ministerial directives are in those other provinces. I mean, there's many clients that I've been dealing with where the plant may be in New Brunswick, but someone from Nova Scotia drives to the plant, different things like that. So you need to kind of be cognizant of what different provinces are doing. So for example, on March 19th, New Brunswick declared its state of emergency and issued a number of directives. And then, of course, on March 22, Nova Scotia declared its provincial state of emergency with similar directives. So you need to look at different provinces from time to time. And of course, the federal directive under the Quarantine Act about international travel and mandatory quarantine. I'm just going to pause there for a moment. So one of the biggest issues, like and I preface this, I should have caveated this at the start for those on the line. I am a management side labor lawyer. There's different types of labor lawyers. There's kind of management side labor lawyers who advise companies, small and large. That's what I do. There are other labor lawyers who are what I'll call kind of plaintiff or union side labor lawyers who advise unions. I don't do that. So I exclusively advise companies and managers. So when I speak, obviously, there's a certain bias I have, if you want to call it a bias, to the management side, because that's my world. That's what I do. That's what I practice. And so this second point that I want to raise on layoffs, this is the most common thing that I have been dealing with as a management side labor lawyer in the last 2 weeks. And I know my colleagues here at McGinnis Cooper, I know there's multiple issues we're dealing with, but layoffs is a big issue. And it's interesting how this question is answered in different businesses. So whether you are in the construction sector or whether you operate small business or whether you're in manufacturing or whether you're service sector, the drivers that are affecting your business are all affecting it differently. And so when I kind of preface this issue of layoffs, you kind of first have to ask yourself the question, what law governs me? And so there are likely people on this call that are what I'll call federally regulated. And if you're a federally regulated employer, then you need to look to the Canada Labor Code and the Canada Labor Code for your direction on what you can do with respect to laying off employees. If you are in Nova Scotia and you're not federally regulated, which is likely 95% of the folks on this call, then you're looking to the Nova Scotia Labor Standards Code. And I can tell you the differences between what a federal employer has to do and what a provincially regulated employer has to do are quite different. And so you have to kind of ask yourself that question. And then you have to keep in mind as well, if you're laying off, and as I mentioned, if you have operations in New Brunswick, what you do in Nova Scotia and what you do in New Brunswick may be different based on the different legislation in those provinces. For example, the concept of a temporary layoff, and I'm speaking a legally defined temporary layoff, that exists in Ontario. In Ontario, you can lay someone off for a 13-week period, in 13 weeks and a 20-week period, and that's a notion of a temporary layoff. Our legislation in Nova Scotia is not written that way. Our legislation in Nova Scotia basically allows for a 6-day temporary layoff, and we all know with what we're dealing with and our curve that we looked at the start, that laying someone off for 6 days is not going to be the solution to the issue that we're dealing with. And then, of course, you need to look, if you're a unionized workplace, you have to look at your collective agreement. And what does your collective agreement say with respect to layoffs? Because as I mentioned earlier, employees employed under a collective agreement are excluded from the provisions on the Nova Scotia Labor Standards Code. And then, of course, you need to look at the written employment contracts that you may have in your workplace. One of the things I've been kind of advising employers as they work through this is to develop a spreadsheet or a tool because most employers, if they have written employment contracts, it's something they've started recently, and what I mean recently, probably in the last 10 years. And so start a spreadsheet and start measuring your risk. Okay, I have 30 employees or I have 25 employees. Sally has a written employment contract, Johnny doesn't. Sally's written employment contract has a termination provision, Johnny's doesn't. Start doing that so you can start to kind of measure and assess the risk that you might have. So this is just a graphical representation of what I just said. And so I'm going to start with the left-hand box first, which is the labor standards legislation. So in Nova Scotia, once again, that's called our Labor Standards Code. And in our Labor Standards Code, there are requirements to provide people with individual notice. And that individual notice is a function of your length of service. So if you've been there between 0 months and 3 months, you're not entitled to any notice. If you're there between 3 months and 2 years, it's 1 week, and so on. It maxes out in Nova Scotia at 8 weeks. We also have in our legislation what we call mass notice provisions, which are when we terminate or lay off more than 10 people in a 4-week period, then everyone, regardless of their length of service, is automatically elevated to an 8-week notice period. and there's an obligation to provide notice to the minister. So all of that being said, we do have a section in the Nova Scotia legislation. The section is section 72 sub 3 sub D, and I call it the beyond the employer's control exception. And the wording is very good, it's very helpful, and it talks about situations where things happen that are beyond your control, and they allow you to lay off the employee without providing either individual or mass notice. And so does that clause actually speak to a pandemic? No, it does not. It does not use the word pandemic. But based on the drafting, we believe as legal counsel that there's a reasonable, more than reasonable chance that what is going on here is something that's beyond the employer's control. And so that exception, there's a strong likelihood of it applying. But as I transition to my next box, the common law, that really only gets you around your obligation to provide notice under the Nova Scotia Labour Standards Code. As we know, I just mentioned, that maxes out at 8 weeks. If I have an employee who's been employed with me for 20 years and they don't have a written employment contract, if I were to terminate them in the usual course without cause, I would owe them a lot more than just 8 weeks. I would owe them what's called common law notice. And so there's a risk in laying people off without any notice whatsoever of triggering what's called a constructive dismissal. And I know, I think it was last weekend or in the newspaper, there was an article in the National Post. Patrick, you're familiar with the article that I'm referencing, where a Toronto, what I'll call employee side lawyer wrote that you can't lay people off, it's illegal, and you have to read the article, but that's what the headline was. And that's what he was talking about, this common law risk of constructive dismissal. Now, I've talked earlier about the importance of a written employment contract. If you have a written employment contract, which many employers do, that says, dear employee, welcome aboard, welcome to our company. We hope our employment relationship is long lasting, but if it's not, here are the provisions that apply in the event that your employment is terminated. And if that contract says, you're only entitled to the Labor Standards Code and not the common law, then your risk is pretty well mitigated because you've already contracted out of the common law. And as we've already mentioned, the exemption for beyond the employer's control would apply for the labor standards. If it doesn't contract out of the common law, well, then there's a possible risk down the road. Let's say we're a month and a half or 2 months into this pandemic, your employee remains on layoff. They could say, you laid me off unilaterally, you gave me no common law notice, I'm suing you for constructive dismissal. That's a risk. I have not seen a case such as that yet. I've not heard of an employee triggering a constructive dismissal as of yet. I have my own opinions and views of that, but that is a risk that you'll have. And there's risk mitigation strategies towards that. When you're laying people off, many of you have developed or will develop letters which call this a temporary layoff. And you'll speak to the employees and say, this is what's happening in the world. This is what's happening to our business. It's a matter of the survival of our business. We're laying you off temporarily. We understand there's some benefits you can apply for federally, and we hope to be able to recall you as soon as we are able to. And so that's a risk mitigation strategy, because if an employee is going to sue you for constructive dismissal, they're making the decision to end that relationship, to consider themselves severed, and to come after you for severance. And so they're making a decision not to come back. And I'd like to think that most employees now, in dealing what's going on in the world, recognize this is beyond employers' control and do hope to have that opportunity to go back and work with you when this is all over. I also can't think about what courts will do with these constructive dismissals. I can only speculate, but a judge is going to have to ask themselves, was it a reasonable exercise for that employee to consider themselves constructively dismissed? Is that a reasonable exercise of mitigation, putting yourself on the job market when you virtually know that there's no job market to be had? And the last box that I talk about is the collective agreement. And because every collective agreement is like its own little set of laws for your workplace, like you're going to have to look at your collective agreement and see what it says upon layoffs. I've seen collective agreements, as I've mentioned, that are at one end of the spectrum that seem to speak almost to this notion that there is no layoffs and we've guaranteed a certain complement of employees' employment. I've seen that. And then I've seen collective agreements that give a right to layoff without any notice at all. And so, so they're all over the place when it comes to collective agreements. So you really do need to look at the specific provisions for your particular workplace. As I've mentioned, there are a number of benefits available to individuals. One thing that, as I mentioned, I've been advising on this now for 3 to 4 weeks. And advice that I gave 3 weeks ago when someone came to me and said, we have someone who needs to self-isolate, the advice you were giving there was, well, EI Sick has just changed its rules. They don't require a medical note. There's no longer a 1-week waiting period. Go through EI Sick. Then about a week later, there was a new benefit called the emergency care benefit, which was for individuals who may not otherwise qualify for EI. And then last week, of course, we saw the Canada Emergency Response Plan benefit, which is the benefit, which is the $2,000 per month for the four-month period. So that's an option, obviously, for employees. As I've mentioned, you should give your employees as much information, help them with their ability to apply for these things, but you shouldn't guarantee they'll get it, or you can't really guarantee when they're going to get it. That's really something that's outside your control. And if you're promising employees they're A, going to get it, or B, when they're going to get it, it's something you're not going to be able to live up to. As well, other solutions that some employers are looking at is the federal work sharing plan. There was some information, Patrick, at one of our sessions from the federal government on that. I've looked at that somewhat, and I have a few clients considering it. It is an application type process. There is some level of detail involved in applying for it. I know online there's a guide to filling out the application, and the guide to filling out the application is 25 pages long. So there is some process to applying for federal work sharing. The other thing that you can do as a risk mitigation, we go back to the constructive dismissal risk, is to implement what we call a supplementary unemployment benefit plan. And that is a plan that you as an employer implement, and you have to implement it before you do your layoffs and before people apply for EI. But that's a plan that allows you to top up someone when they're on EI. And many of you may already have these supplementary unemployment benefit plans in place and don't know it. I know many employers will top up individuals who go on maternity or parental leave. Well, in order to do that, you had to have filed a supplementary unemployment benefit plan. So you may actually have a draft or a precedent in your workplace that you could customize for this situation. And once again, as a risk mitigation strategy, if you're laying your employee off temporarily, they're hoping to keep that lifeline to your workplace so that they can come back. And you've provided some degree of top up, which is a little more than the minimum. That's another risk mitigation strategy. I'm now moving on to the third kind of basket of frequently asked questions, and that's as it relates to the Occupational Health and Safety Act. And we have to remember when we talk about the Occupational Health and Safety Act that there's kind of separate legal obligations in there. In Nova Scotia, Section 13 is the employer's obligation, and that's what I have shaded in black on this slide, that it's employer has the obligation to take reasonable precautions to ensure the health and safety of persons at or near the workplace. So that's the employer's obligation. But we have to remember that Section 16 places an obligation on employees as well, a legal obligation, and that is to protect their own health and safety and that of other persons at or near the workplace. And so when it comes to things like this COVID-19 crisis, and we say to employees, you are required to only remain in that part of the plant, or you are required not to do this, or you are required to do a daily screening form before you come to the workplace, and they say, well, I'm not going to do that, you can point out to them that their legal obligation under the Occupational Health and Safety Act is to protect their own health and safety and that of other persons at or near the workplace. So that's a helpful tool to remind employees that when it comes to health and safety, it's shared. We actually call the system the internal responsibility system, because it's all of the workplace players, whether there's an owner of the site, there's a contractor, there's an employer, there's employees, we all share the obligation for health and safety in the workplace. When it comes to specific preventative measures that employers need to adopt, I think we're all familiar with the easy ones. And the easy ones are depicted here in this photo, which is frequent hand washing and providing all of the additional sanitizing equipment and sanitary materials to allow individuals to be safe in their workplace. If we were just talking about office environments, then that's pretty easy to manage. Wash your hands frequently and we'll sanitize and do extra cleaning and that type of thing. However, the workplaces in Nova Scotia are pretty varied. Your workplace could be a bus, could be a fishing vessel, could be an industrial facility, could be a gas station. All of these types of things are different, and they require you as an employer to think differently about what preventative measures you can apply. And in some cases, they can be things like personal protective equipment or PPE. They could be devices, they could be gloves, they can be respirators, things of that nature. PPE is a solution, but it's not a complete solution. We also have to look at some of the more complex control type systems, and I've alluded to some of them already, where it may well be that, if anybody goes to, for example, if you've been to a grocery store lately, if you've been to Costco, if you've been to some of those retailers, they've done some very creative things with social distancing, demarcating that, having a decreased number of individuals in the stores. So those are the things that you're going to have to get creative on. And I have some experience working through some of these solutions with clients. In particular, when you think about home delivery. So what about those clients that have a home that are going to be delivering things to people's houses? There's a bunch of risks involved with that. What about those clients whose business requires them to actually go into people's houses? So it may well be that I have a contractual legal requirement to service a certain piece of equipment in your house, and if it's broken down in the still winter months, I have to fix it. How do I interact there? Or as I've mentioned, manufacturing facilities where I may have 100 people on a floor at a certain period of time that are used to kind of milling about on this floor. How do I control and make sure that social distancing is maintained? So those are some of the things that you need to really think about. It's going to involve rearranging the way you do business, rearranging the schedule you do business, rearranging your shifts potentially. But all of those things are tools that you can work through in trying to devise a system to deal with this. One of the questions I'm asked is kind of what do we do if we end up having a person in the workplace who tests positive for COVID? Well, a lot of that is going to be dealt with, and some of you have already experienced that. I know of certain clients that have had that happen. But a lot of that is going to be in your control, and a lot of it is going to be outside your control, because that person is not going to be diagnosed by you in the workplace. That person is going to be diagnosed at a hospital. And once they're diagnosed, then the directives given to them from public health officials are something that they have to comply with and you have to comply with. And a lot of the things when it comes, we keep hearing that phrase contact tracing, where someone has shown up at the hospital, they've tested positive, and public health is then going to start the contact tracing. That's not something that you are necessarily taking the lead on as an employer. It's something that's going to impact your workplace because the contacts they may have had in your workplace. And so, it's something you're going to work in cooperation with public health on. It's not going to be something that you are going to have to bear the burden of yourselves. But some of the best practices are obviously that as soon as someone is diagnosed, public health is notified. That person is obviously sent home for self-isolation until such time as they're symptom-free. You as an employer, you should check in with them. You should make sure they're doing okay, like you normally would with an employee on sick leave. The public health is going to start the contact tracing process, of which you should cooperate with, and you should work with your workplace. You're going to need to communicate in your workplace what's happened. Otherwise, the gossip mill is going to bring your workplace to a halt. And so you're going to need to communicate what's happened. As I mentioned earlier, privacy laws are not suspended. So us able to say, hey, everyone, we're letting you know Sally tested positive for COVID-19. That's not the right strategy. But identifying and speaking and saying we've had a case and we're managing it, and this is how we're resolving it. You're going to have to consider a communication strategy in that respect. Your EFAP, if you have it, employee family assistance plans, you should engage those. You're going to need to think about sanitizing your workplace. If you haven't already, I've reached out to a few clients in the sanitizing space, and I've said, are you guys equipped to do full kind of biohazard sanitizing for COVID-19? Because if you are, I'd like to put you on a list of clients that I can give your names to, and that's someone, if someone on this call with the chamber does that, that's good to know. You're going to need to think about how long you might have to close a certain workplace or a certain section of that workplace. I know the medical, once again, the medical advice I've been giving, I'm giving another shout out here for Dr. Matthew Bernstein. You do need to consult with some medical experts on this because what I've been told is that on a hard surface like stainless steel or a wood desk, the virus can survive for as long as 72 hours. There's other substrates or medium of which the virus survives a much shorter period of time. Dr. Bernstein's given me some advice about how long it can survive on cardboard, how long it can survive on paper. So things of that nature you'll need to take into consideration in determining how you deal with that. The next piece is under occupational health and safety is what we refer to as work refusals. And everyone in every Canadian province has the right to refuse unsafe work. And so if I show up at my workplace and my boss says, I want you to climb that rickety ladder all the way to the top and then cut those tree limbs, and I think, geez, that's unsafe, I don't have fall arrest, I can refuse doing that work. And that sets in place a legal process in Nova Scotia under our Occupational Health and Safety Act. And for those of you that Google and want to read it, in Nova Scotia, the right to refuse work is at section 43 of the Occupational Health and Safety Act. And the legal test is, as you've got there on the slide, from the statute, it says where the employee has reasonable grounds for believing that the act is likely to endanger the employee's health or safety or the safety of another person. And so, and there are some exemptions. For example, if your job normally involves a danger that's inherent in the work, that's an exemption. Or if your refusal puts the life of someone else at risk, those are exemptions. But basically what this does is it sets in place a process, and in most provinces it's the same, but it's a process where I go to my employer and I say, I'm refusing this unsafe work. My employer gets the first crack at resolving the issue. And they can come over and they can say, oh, we can change this and we can modify this and we can do this. And if I'm satisfied with that as the employee, then work refusal is over. If I'm not satisfied with that as the employee, then I as the employee have the right to elevate that to another level. And the next level that I elevate that to is to the Joint Occupational Health and Safety Committee that exists in my workplace. The Joint Occupational Health and Safety Committee, they then try and remedy the situation. And if they resolve it to the employee's satisfaction, work refusal over. Remember, the Joint Occupational Health and Safety Committee is comprised of both representatives from management and both representatives from the workforce, whether you're union or non-union. So you get kind of a neutral view. Lastly, if I'm the employee and I'm still not satisfied with what the Joint Occupational Health and Safety Committee has done, I can go externally to the Department of Labor and I can contact an officer with the Department of Labor who will come in and who will assess the situation and issue an order whether or not it's unsafe work or orders me back to work. And last but not least, I can appeal that as an employee. I could appeal that to the director and ultimately to the Nova Scotia Labor Board if I so choose. Keep in mind, while an employee is refusing unsafe work, we have an obligation as their employer to pay them while they're refusing unsafe work. And we also can assign them other work that is not in any way related to the unsafe work that they've refused. And we can also take another employee and we can assign that other employee to the work that that person's refused. However, we have to give full disclosure to that other employee. We have to say, Sally has refused this work. Here it is. Here are the reasons she's refused. We think it's safe. We're asking you to do it. Will you do it? And if that employee chooses to do it, then they'll do it. The other thing to keep in mind is that in Nova Scotia, there is another section of the legislation, which is section 45, which prohibits discriminatory action. And we use the word discrimination. I've already used the word discrimination in talking about human rights legislation. We can't discriminate based on race or gender or ethnicity. But in the OHS Act, the word discriminatory action refers to me as an employer taking an adverse consequence against an employee because they've raised a safety issue. So if my employee files a work refusal and I say, you know, darn it, I want you doing this work and I'm writing you up, that could expose me to a complaint under the Health and Safety Act of discriminatory action. So when it comes to and I'm going to go back here for a moment, when it comes to work refusals, on my slide, there is a legal test, there is a threshold, and it's got to be something that is a sufficient likelihood of a danger, not the mere presence of a risk, okay? So when it comes to COVID-19, there are likely cases where there could be unsafe work, where someone may be justified to say, that's unsafe. But then there's probably a lot more cases where people are anxious, and there's a risk, but it's the mere presence of the risk does not necessarily and does not allow me to file a work refusal. The other thing we do is we always look to legal precedent and case authority, and there's actually quite a few cases on work refusals that surfaced during the SARS epidemic. So when SARS was going around, and I won't bore you going through all these cases, but I've got cases here involving someone who worked at the Canada Customs Revenue Agency. I've got cases involving someone who worked at Human Resource Skill Development Canada, Air Canada. And in those cases, in many of those cases, it was found to be the mere presence of a risk and not a sufficient likelihood of danger. In one of the cases, there was found to be a sufficient likelihood of a danger.
Brad, just as a heads up, we're about 10 minutes, so I'd love it if you could still answer a few questions before we finish at 11.
Certainly, this is my very last slide, Patrick, so it's thank you for, and this one is really quick. This is basically just pointing out that in Nova Scotia, individuals who get hurt in the workplace or develop a condition in the workplace, they can apply for workers' compensation benefits. I've not seen this yet. I only throw it out there as kind of a legal issue that is a possibility, and that is whether someone who contracts COVID-19 as a result of their work. So, I come in, I go home at night, and if I get COVID-19 at the grocery store, well, that's not work related. But if my job is to service or help individuals that actually have COVID-19 and I develop it, I just point out that there is some authority in other provinces. For example, in Ontario, there were a number of compensable workplace accidents for individuals who developed SARS during the SARS epidemic. And so, Patrick, that concludes what I was going to talk about.
Great. Okay, thanks, Brad. I just wanted to get myself off mute there. Sorry about that. Great. I wanted to, I do have a few questions here that I'll jump into. Severance. Is severance required with temporary layoffs? Or I did sort of answer this because I think it maybe the Canadian Emergency Response Benefit would now cover this.
So severance is a non-legal term, okay? So, well, I should say in some provinces it's a non-legal term. We use the word severance kind of what I'll call as, when I hear my neighbor says, geez, they're giving me a severance package. I think of that as kind of a non-legal term. What that really means from a legal perspective when someone's giving you a severance package is we go back to, if I go back to my slides here, bear with me. If I go back to this slide, when someone's giving me a severance package, they're giving me a sum of money. Because remember, the first principle of severance, the real legal term is reasonable notice. And we hear the word notice. And so in the first instance, if I'm going to let someone go, I'm supposed to tell them in advance. Patrick, thanks for helping us here, but we're giving you notice that next month you're gone. I'm giving you advance notice. And so that's cumbersome in many workplaces to give people advance notice. You have that terminated employee coming into the workplace. So we give them what we call pay in lieu of reasonable notice. And we call that severance. So when I look at this slide that's in front of you now, severance is covering off in the normal course, labor standards severance, labor standards notice, which for an individual is either 1 week, 2 weeks, 4 weeks, or 8 weeks under the Labor Standards Code. And for those that don't have a written employment contract, it's covering off the common law, right? So if we go back to what I'm saying, if we take this conversation and make it specific to COVID, we believe that there's a strong likelihood that what's necessitating the layoff, and this is obviously in any specific workplace, is something that's beyond the employer's control. Because there are employers out there. For example, I alluded earlier to cleaning companies. I don't know if this is fact or not, but if my business as a cleaning company, because everyone is doing this extra sanitizing, if my revenues have gone through the roof because of COVID, because I'm doubling up and doing more and more cleaning, I can't really lay people off for something beyond my control. But for other businesses, like if we take a restaurant or a dental office where I can't actually have people come in, then my revenues are dropping off. And I didn't see it coming. I didn't plan for that when I started this year on January 1. So because it's beyond my control, I'm going to say that I'm going to take advantage of that exemption and not provide the statutory notice or severance, okay? And when it comes to the common law, if I've got an employment contract, I don't have to provide anything at the common law because I've contracted out of it. And if I don't have an employment contract, there is a risk of severance still. I can't say there's no risk, because that employee in a month and a half's time or 2 months' time could say, I am now, you've severed me and I want my severance. So that is, it's a loaded question in the sense that what are most people doing? Most employers, at least the ones that I'm talking to, a lot of them, I shouldn't say most, but a lot are laying off without a severance at this point in time, with the hopes that this will be temporary and they'll recall people. But I can't tell you conclusively that there's no risk of severance down the road for employees that have a common law entitlement.
Okay. Second question, let's assume an employer has most of their employees working from home remotely. Let's hope this is all over by April 20th and all of the employees are called back to the office on April 20th. However, since school is still off until May 1st, there may be a number of employees who have to stay home to take care of their children. The employer is suggesting that the employee take vacation to take care of their children, and therefore they would not have vacation for the rest of the year. Is that okay?
So this is a good question, and it actually I'm just looking here at a client that sent me something here today, and this is a client that tends to be kind of more at the advanced end of things from time to time, and I'm just looking for the word that they've used here in this document that they've provided. They are calling it a pandemic recovery plan. So they have already, they're already kind of down to a skeleton crew. They've sent people working from home, and they are very, very eager as soon as possible to start that revenue flowing again, because they're in an industry where there's penalties for being late and all this kind of stuff. So they are now starting, not only do they have their pandemic plan running, but they're starting to do a pandemic or a recovery plan where they're looking at, just this very question. And so I guess a lot of it's going to depend on this Serb benefit, because it may well be that we don't want everyone rushing back to the workplace on day one. I mean, that might be a little unruly for you to have everyone come in. So you may want to do it in a staged process. And for those that don't have childcare, then if the Serb is likely still going to, I call it the Serb, the CERB, the Canadian Emergency Response Benefit, it's still likely going to be there to cover them. And if it's not, and they run out, then they're going to have to consider things like a drawdown on their vacation. Or I've heard of some employers that, before some of these benefits were announced, were letting people take an advance on their vacation. So your question's a good one. It's something you should be thinking about. You should start developing your recovery plan and how you're going to deal with this. But there's too many uncertainties to give you a definitive answer as to exactly what you do, because we just don't know when that date's going to be. And April 20th, I don't know, you're sounding optimistic based on the science and the stuff that I'm hearing. But start thinking about that, and as things develop, you'll get a better sense of what benefits or safety nets are there for people.
Okay. Response to Ashley Downing, and Ashley, I'll respond. You asked about clarification regarding the CERB or the Serb plan. Working while EI. I understand the Serb plan allows for no working. I do not believe that is the case. I believe it allows for 14 consecutive days. So long as you're off for 14 consecutive days, I should restate it. So long as you're off for 14 consecutive days, you can qualify for the Serb benefit. I think this is still a moving target. I think that Serb benefit is going to change, and I think they're going to allow some increased flexibility around that. But at this point, the letter I have from Service Canada as of Friday, was as long as you are unemployed 14 consecutive days, then you can apply for the Serb benefit.
Yeah, Patrick, you might be more up to speed than me on that, because I know there's a bunch of unanswered questions I have about the Serb benefit and whether or not a sub can top up a Serb and things of that nature, which I have not been able to find definitive answers to. Perhaps you have.
No, in fact, I've been looking very hard to determine if you can get additional income. And the best response I have so far with the Serb benefit is you have to be off 14 consecutive days to qualify for the Serb benefit, which seems silly. So we're talking to a minister tomorrow on a call. So my hope is that we can bring that up and get that adjusted.
I'll just make this one comment. As a lawyer that kind of monitors changes to legislation, I mean, you know, no offense to regulators and legislators, but it's not something that usually occurs that quickly. Like there's usually consultation periods and first and second, third reading, and sometimes it can take over a year for some of these legislative changes to happen. This Serb benefit is a creature of a statute of a parliament, and it is amazing to see how fast our government and our legislators have been moving on this. It's commendable in a way that they've actually drafted a complete statute on this and got it out. The regulations are yet to come, and the application documents are yet to come, but it is moving very quickly.
Yeah, perfect. So I have one last question here. I'm just reading it. Let's see. We have from C4. We have employees at home utilizing accrued time off. They accumulate this time while working away from home on weekends and holidays. It's then either taken as time off or paid out at management's discretion. If we were to consider salary reductions as temporary measures, should the employment situation change where we need to commence some layoffs and we have the accrued time as a liability, will that liability be valued at the reduced salary or at the salary level prior to a wage reduction? Oh my goodness.
Yeah, so look, my thoughts on that are that it's going to be valued at, like, they earn that. So it's like if someone earns overtime, then you pay out that overtime at either what the legislation says, so time and a half their regular rate in Nova Scotia, or if you've contracted for even a higher level of overtime, they've earned it. And the first principle of overtime or lieu time is, you give them the cash and they put it in their pocket after they've earned it. A lot of workplaces, they'll come up with bank systems or, in different systems. And the concept is that they've already earned that at that rate. So my initial reaction to your question, without seeing your policy or seeing how it's written, is if they've earned it at a certain rate, you can't then kind of devalue that kind of after the fact. But you probably want to have a look at what does your policy say on this lieu time or this bank time. Is it in days, or is it in hours, or is it in dollars? And what legal interpretation can you take of that? But my gut is if they've earned it, then they've earned it at that rate.
Okay, that's great. I'm glad you understood that. Thank you. And finally, from Julie to everyone, do you know if the Serb backdates to pay for the first 14 days you don't work, or does it start at the end of the 14 days? My understanding, Julie, and sorry, I'm going to answer this, Brad, is in the letter I received, it just says 14 consecutive days. It does not clarify whether it's first, last, or in the middle. Okay, so 14 consecutive days at this point. But again, I really think that Serb benefit is going to change. There could be changes today with Minister Morneau, although he's talking about the wage subsidy, and I would encourage folks to take a look at that as well, because I think that will be very, very important. At this point, Brad, I'm going to thank you and try to wrap things up. We're pretty much on time. Thank you very much for joining us today. I would encourage everyone to join us again tomorrow when we have April Strike, who's going to talk about mitigating financial risk at noon. So I'd encourage you to sign up to that webinar. So thank you very much, Brad. Really appreciate you joining us today, and thank you everyone else.
Thanks everyone, I appreciate it. Thank you.
Thank you.